Good morning, everyone. I hope you can hear me okay. Welcome to this webinar. I'm going to be chairing today's session. I'll just introduce myself first. My name is Cynthia Orchard. I am a consultant policy advisor with the European Network on Statelessness. I've been collaborating with ENS in various ways since 2016, and it's really a pleasure to welcome you here today. And it's great to see that people are joining from lots of different places. That's wonderful. I'll do just a really brief introduction to ENS and this series of webinars, and then I'll hand over to our speakers today. As a network, ENS collaborates with members and communities impacted by statelessness to build awareness about statelessness and to advocate for the rights of stateless people throughout Europe. This webinar will look at identification and determination of statelessness in the refugee reception and refugee status determination procedures. It's the second of a series of 4 webinars organized by ENS as part of our Stateless Journeys campaign, which aims to improve the rights of stateless refugees in Europe. If we could have the first slide, then I'll also just speak really briefly about that. There's also a related series of short briefings on the Stateless Journeys website, and you can see on this slide the different topics that are covered by these briefings. So we encourage you to go to the website and have a look at those. And we hope that this and the other webinars that we're doing in this series will spark lots of discussions and connections that go beyond the webinars. And we warmly invite you to connect with ENS after this event or after the other events. There are also always multiple opportunities to get involved with ENS's work. And including, we've got a big conference coming up in Madrid in June, and we'll share some more information about that at the end of this session. And we hope that many of you will be able to attend that conference. Just a couple of short housekeeping points. This session is being recorded. Your cameras will be off throughout and your microphones will be muted. But we hope that you'll be able to participate by putting questions or comments into the chat. And we'll try to pick up any questions that we can at the end of the session. We'll have hopefully about 10 minutes for a Q&A after the speakers. And we'll try to address as many questions as we can. So I'll now introduce our speakers for today's session. We'll be hearing first from Patricia Cabral, who is the Legal Policy Coordinator at ENS, and I'm sure some of you know her. Patricia supports law and policy developments and coordinates ENS's strategic litigation activities and human rights advocacy. She manages the Statelessness Index and the Statelessness Case Law Database, which are 2 online resources that compile information about law, policy, practice, and jurisprudence on statelessness across Europe. Prior to joining ENS, Patricia worked as a legal researcher on asylum and children's rights at the Airy Center, and she practiced as a lawyer in Portugal before that. She holds an LLB in law and an LLM in international and European law, and she's truly wonderful to work with. Following Patricia's presentation, we'll be hearing from Claudia Bonamini, who's the Policy and Advocacy Coordinator at the Jesuit Refugee Service in Europe. Claudia has been working with JRS in Europe since 2017. And before that, she worked for about 9 years at the Belgian NGO Flemish Refugee Action, where she held mainly policy and advocacy positions and specialized on issues of access to protection for refugees, the asylum procedure, and EU asylum policy and legislation. She holds a degree in political science and a master's in human rights and democratization. It's great to have you both with us today, Patricia and Claudia. And Patricia, I will hand straight over to you, and you've got about 15 minutes.
Thank you, Cynthia, and thank you for this wonderful introduction, and also for reminding the audience of that this is only the second webinar, and much of what I'll be saying on today is really building up on some of the topics that we've already started exploring in the last webinar and that we will continue to explore. So welcome if this is not the first time you're here, but also welcome if it is, and we're going to try and give you a brief overview of why this issue is important, but also what you can do about it. It's not just looking at the issue, but also thinking positively in terms of how can we address it together. So what exactly is statelessness? To be stateless is really to not be recognized as a national by any country in the world. And today it affects over 500,000 people living in Europe, both recent migrants and refugees, but also people who have lived in the same place for generations. Particularly stateless refugees are among those seeking asylum in many European countries. And when we look at the top countries of origin of refugees in Europe, we see some countries that have really significant stateless populations. So for example, Syria already had quite a large stateless population even prior to the conflict, including 500,000 Palestinian refugees, hundreds of thousands of stateless Kurds that were living in Syria. And it also has discriminatory nationality laws, which means that women cannot pass on their nationality to their children. And this adds more layers of displacement and risk of statelessness, both for the stateless refugees themselves, but also for their children who may even be born in Europe. Also, Afghanistan, for example, has a large population of stateless people, and a lot of people that have been displaced for years, which means they've also had difficulties in acquiring identity documents or proof of citizenship, and leading to several risks of statelessness. But also Iraq, for example, has significant populations like Palestinians and Kurds and other minorities. So these are just some of the examples for you to understand how this issue may be coming across in Europe, including sometimes hidden a bit in the numbers. A person may be recorded as being Iraqi, for example, but actually being stateless because they can't acquire a proof of Iraqi nationality, or they have some other circumstances. And being stateless really has a devastating impact on someone's access to their own rights, as well as to their sense of belonging. In Europe, our asylum systems are largely based on the assumption that everyone has a nationality. So many of the stateless refugees who reach Europe and apply for protection are not identified or recognized as stateless, which can really lead to serious problems. And our Stateless Journeys campaign calls on Europe to fulfill its duties, not only to identify stateless people, including, for example, in identification, registration and screening procedures, as we've heard from Zoe and the UAA on the first webinar, but also in taking the next step to protect stateless people in the context of migration. So what's the issue? Failure to address statelessness in this context of refugee reception and refugee status determination can really put people at risk and causing serious human rights violations. These are some of the examples of which complications can we see when statelessness is not properly addressed. Stateless refugees may, for example, be required to stay in refugee reception centers for prolonged times due to uncertainty about their nationality. In some cases, that may lead to being detained or having unlawful restrictions of movement, which violates the standards in reception conditions, including those set forward in EU law. Stateless refugees from some countries, when their statelessness is not addressed, may also, for example, at the end of an armed conflict, be forced to return to their country of former residence, but where they can also still face risks of discrimination and or persecution. So the reason why they may be fleeing is not just related with the armed conflict, but there may be other reasons related with it, which also need to be considered during the refugee status determination procedure. Refugees whose statelessness has not been addressed and who are denied international protection may also be unlawfully detained for prolonged periods of time, while states are attempting to return them to a country that does not recognize them as citizens and therefore is not willing to accept them back. And then, as I mentioned, there are also children of parents who are not recognized as stateless, that may be born stateless in Europe or may be born in transit and on the way to Europe, and who are denied their right to a nationality, which is a right enshrined in the Convention on the Rights of the Child. So again, identifying these children as stateless, but also their parents, means that we can better address the risk of statelessness among these children. And we're going to hear more about these issues of detention and children's rights in the next few webinars. And Here are the words of a person who interviews, who prefers not to disclose their name, and who really shows the problem of not addressing statelessness properly from the beginning of the procedures. And this is a Kuwaiti Bidun man who is currently living in the Netherlands. I went through 3 asylum procedures and 1 no-fault procedure. Statelessness was not considered as a ground for asylum. And in the 3rd asylum procedure, he was finally granted international protection, but on different grounds. I feel discriminated against and rejected. I can't go anywhere. And this shows how the lack of awareness and information from the decision-making authorities about statelessness and nationality can really have a serious impact on a person, and forcing someone to go through multiple procedures really delays their access to protection and safety, and potentially forcing the person to relive traumatic experiences. So identifying and protecting stateless people is not rocket science, but it does require awareness of these issues. So we will be unpacking some of those essentials today. First, how to identify statelessness. And if you're coming new into this, there's quite a few resources that you can use, and that includes some of the key questions to ask yourself or to ask to the person who may be stateless in order to try to identify whether there's a risk of statelessness. In our Stateless Journeys website, we have published a list of questions to help identify the risk of statelessness, and we can share that in the chat as well. But some of the questions include, for example, of what country do you consider yourself to be a citizen, or any at all? And do the authorities of any country consider you to be a citizen? Have you previously held any other nationality? What are the nationalities of your parents, of your grandparents? Are there any barriers in inheriting those nationalities? Do you have any national identity card or a passport? And if you don't have one, why don't you have one? All these are, for example, questions that can really help assess whether there's a risk of statelessness or an issue with confirming the nationality of that person. Then we also have a guide published by the UAE, which is the practical guide to registration, and it's used by authorities responsible for the registration of applications for international protection, but it can also be used later as guidance in asylum procedures. It includes a section on statelessness that clearly explains what it is, why, and when it may be relevant to the work of the authorities, including, for example, common indicators that a person may be stateless. Then our ENS member, Forum Refugee, has also developed a multilingual toolkit for the identification, support, and referral of people at risk of statelessness, which is currently available in French and in English. But it is also intended to be used as a template for other partners to develop their own toolkits and improve the identification and support in each country. And then finally, referring to comprehensive country of origin information that contains specific information on statelessness is also crucial. Also, an ENS member, Stateless, has recently published a document with a principle for conducting country of origin information research on statelessness, and it also published a report on stateless Palestinians in Lebanon. So we do hope that more of this research can be published by other partners as well, and that decision making is also based in this reliable country of origin information. Also on the Stateless Journeys website, we have the country position papers on Myanmar, on Kuwait, Iran, Iraq, and Syria. And all of these provide more information about some of the main stateless populations in those countries. So looking specifically at the asylum procedure, how do we determine statelessness in that context? Statelessness can be determined through a dedicated statelessness determination procedure or as part of a refugee status determination procedure. So the risk of statelessness itself should be identified at registration, but then determined later as well with the legal assistance and other safeguards in place. And the same principle should apply across any determination procedures. So there should also be, for example, appropriate links and referral mechanisms between the refugee status determination procedure and the statelessness determination procedure that could be in place to avoid people not being adequately identified and recognized. If the person applies both for asylum and statelessness, then it's also important to respect the principle of confidentiality in asylum procedures. And so the asylum claims should take primacy and be assessed first. If it is necessary to approach the authorities, for example, of the country of origin to confirm that the person is stateless, that's something that we cannot do if the refugee is facing persecution exactly from those authorities. Some examples of good practice. In Italy, UNHCR and the NGOs have been advocating for having a referral mechanism among the relevant authorities. That's not in place yet, but we've seen, for example, a recent judgment from the Court of Florence who recognized the statelessness status of an asylum seeker who had been denied refugee status. So his lawyer lodged an appeal against the refusal to grant him refugee status and asked the judge for a preliminary assessment of the applicant's statelessness. And the court considered that there's a connection between statelessness status and the asylum request and decided to handle them in the same procedure. In France, there's also, for example, a lot of cooperation between the Office for the Protection of Refugees and Stateless Persons, the Ministry of Interior, and UNHCR, all of whom can refer people to the status determination procedure. And if a person submits an application for asylum and a statelessness status, the asylum procedure takes priority, as I said, was ideal. And then the authorities can also grant a refugee statelessness status without the need to formally initiate a new status determination procedure. And a second thing to note on this is if we're looking specifically at the refugee status determination procedure, statelessness itself can be a grounds for persecution. It may be linked to a reason based on the Refugee Convention or not. But for example, lack of nationality may be part of the reason why the person has left their country of origin. For example, Rohingya faced persecution based on ethnicity and were denied nationality in Myanmar. Or other stateless people may be among those displaced by more generalized conflicts, for example, stateless Palestinians and Kurds fleeing Syria. But in either way, statelessness should be properly determined and recorded, and stateless persons should be protected. There are also situations where the consequences of statelessness or the reason why the person became stateless may be considered a ground for persecution under the Refugee Convention. For example, if the person has been denied nationality based on a protected status, race, gender, ethnicity, as we've seen for Rohingya, or if the person has been deprived of nationality in violation of human rights law, or they're refusing to allow the person to re-enter the territory. And then another example is the one that we see here from the UK courts, particularly regarding Kuwaiti bidun. So already in several decision makers have generally found that undocumented bidun suffer treatment amounting to persecution on the grounds that without documents, they cannot access any form of social services. They can't access education or healthcare or benefits. So a UK court has found that the authorities in Kuwait acted to exclude most bidun from Kuwaiti nationality and the residence permit, and this grants them very limited access to economic and social rights, which is part of a deliberate state policy to drive large numbers of bidun out of the country and therefore amount to persecution. And another final note in assessing statelessness within the refugee procedures is that the evidentiary requirements should be fair. So it's very difficult to prove statelessness sometimes. It means proving a negative. And stateless refugees themselves may not be aware that they are stateless, and they may not raise it with the authorities, but that should not affect the credibility of their claim. And the authorities should also initiate themselves investigations to assess that within the limits of what is allowed in terms of confidentiality. But they should also, for example, accept non-documentary evidence and give them the benefit of the doubt is no other evidence is available. Giving you a bit of a minute to take on all of that information, and I know it's a lot, so if you do need to digest it, you're also welcome to get in contact with us later and ask any questions about it. But what can you do as a frontline refugee practitioner? We have 4 R's that we really recommend you to remember. Recognizing statelessness, recording statelessness, risk of statelessness whenever you come across it, referring people to get expert advice, support and information, and we're always happy to provide references and put you in contact with someone in your country who could provide that kind of support and advice, and also reading more about statelessness and determination procedures. At the policy level, what needs to change? Agencies should provide, agencies providing reception support to asylum seekers should provide at least basic training about statelessness and nationality, and also where to signpost people for expert advice. But asylum seekers themselves should also receive information about nationality and statelessness issues and where they can access more information to advocate for their rights. There should also be standardized procedures to identify and assess statelessness in the asylum context. And states should establish dedicated statelessness determination procedures leading to a dedicated protection status. We also have more resources on this, but not all of the countries in Europe, only 11 of them have dedicated procedures in place. Training should also be provided to lawyers and to the officials who are responsible for making decisions on claims for international protection. And then finally, governments should really adequately fund the preparation of country of origin information by experts, and that contains specific information on statelessness that can be used in decision making. And with that, I'm going to wrap up my presentation, but I can't do it and finalize it in better words than Salka, who's a stateless changemaker living in Spain, who more about her is on our website and her story as well. But in Salka's words, Europe needs to take action on stateless refugees because it is time to let them be part of the society where they live. And integration begins with the acceptance of the welcoming state. So hopefully I have given you some inspiration and some resources today to start this as well and to continue doing work on these issues. And we're very happy to continue collaborating, but also taking any questions now. Thank you.
Great. Thank you so much, Patricia, for that really comprehensive introduction to this issue. That's really helpful. I'm going to hand over now to Claudia, and then we'll take questions for both of you at the end. So Claudia, if you'd like to unmute yourself and go ahead, you've got about 15 minutes. Thanks.
Thank you, and thank you to ENS for giving me the opportunity to be here today. So I will try to give you a little bit of an idea about what JRS is doing in Europe, and particularly when it comes to statelessness and stateless people. Before, maybe in a few words, what's JRS? The Jesuit Refugee Service is a global organization, Christian organization. We are present in about almost 60 countries worldwide, and in Europe in 23 countries, not only European Union, so both the European Union and non-European Union countries. Our mission is to serve, accompany, and advocate for the rights of refugees and forcibly displaced people. And the work we do at the European level, well, in Europe, so in all the different countries where we're present, is very different. But there are some common denominators, let's say. First of all, despite our name clearly focusing on refugees, we do not solely focus on issues of protection of refugees and asylum procedures. In fact, very often we tend to work with people that are not, at least not formally recognized as refugees. We also work very often outside of more formal schemes, so formal even reception schemes at the national level. Sometimes we are part, so sometimes we are providing services within, for instance, a national reception scheme for asylum seekers, but very often we are working a little bit on the side, very often in a bit of the gray areas. And we have a special attention to the issue of destitution. We work a lot with people that, for many reasons, end up being destituted and often undocumented in Europe, but maybe, in fact, they are refugees and they should be recognized as such. Now, we work, our style of work is rooted into service and accompaniment, which means that we really strive to be in close proximity and direct contact with the people we serve, and an element of listening and taking time to talk with people, understand their situation and understand their needs is something that is really central to our work. I'm saying all of this because I think that this way of working is also what makes us, what enables us to be in contact, to encounter in our work regularly, maybe more than other organizations, also people that are stateless. Because stateless people, we just heard also from Patricia, they often fall out from existing procedures, existing reception schemes, existing support systems, And that's where then we might find them very often in the institution. In fact, very often after very long procedures, repeated asylum procedures, repeated other kind of procedures, and very often without support. So what do we do then? What does JRS do then? Well, the answer depends a lot on the national level, on the national situation, and also, of course, also with the very individual situations, because they are all very, very different and very specific. Well, I would say indeed that we try to follow also the R's, the 4 R's that Alicia was talking about, and the first one being recognize. So I think recognize that there are potential situations, at least, of risk of statelessness, and being alert. I think in some cases, JRS is also involved in accompanying people during their asylum procedure. This is the case, for example, it has been the case for many years in Romania. JRS Romania was active in accompanying people during their asylum procedures. And before having, for this webinar, I had a conversations with them and to understand a little bit what their perspective was. And they were telling me, well, first of all, we are very aware that there are, and as Patricia already mentioned, there are some countries where already our red flag raises. So if people tell us that they come from a certain country or that they belong to a certain ethnic group or ethnic minority, then we already kind of maybe go and inquire a little bit more about the issues of nationality, whether they have a nationality, whether they have documents proving that, so that the awareness of there might be here a risk of statelessness that can be also relevant in the asylum procedure is there, and then that this can be brought up. They were also telling me sometimes it's a little easier, and inverted commas, when people self-define themselves as stateless, because in that case then they know kind of how to try to go and accompany them, and also how to help people to present their claim also with the asylum authorities. But very often, in fact, the people they meet, they are themselves not aware of being stateless, and this is a result of often a long protracted kind of displacement. And in that case, then this, in fact, they see has a very strong impact during the asylum procedure in the phase of credibility assessment, because people often they claim they generally are convinced also that they have a nationality of a certain country, but they have maybe been living for a long time in another country, and they are not able to prove their nationality, and then they are not also able to answer the questions that usually asylum authorities ask to then verify if someone is really from where they say they are from, because they have been away for such a long time. And in that sense, then they end up in some sort of a limbo, and very often their asylum claim is rejected, and with all the consequences of that, because then they will often end up in a situation of unreturnability, with many consequences that are related with that. So in the case of JRS Romania, what they were telling me was, well, if people if people are stateless but have a clear connection, have a clear protection need that is that they can substantiate, they are coming directly from the country where they used to live, and they can show that they have a coherent and consistent story to tell. During the asylum procedure, we don't even encourage them to mention too much about the fact that they might not have the nationality, because in Romania there is no statelessness recognition procedure, and then they are like, okay, if there is a protection claim, we stress the fact that these people are refugees no matter what, and that they will need a protection status, and that's the best status they can get in our country. So they are a bit pragmatic in that. They're like, we're not insisting too much on the issue of statelessness. We go for the protection. Of course, in other cases, then where the issue of credibility that I was mentioning comes more to the forefront, then they will try to help people to unpack their story, to deconstruct the situation, to make to help them to have a credible claim, and explain to the authorities that why they do need protection. In Romania, they also have a toleration status, so very often then JRS goes on helping people that end up not being recognized with a protection status in a procedure of non-returnability, and then hopefully eventually also to a procedure of obtaining the Romanian nationality, which then solves obviously the problem of statelessness. There are other countries where JRS also is often confronted with the situation of stateless people, Belgium being one of them. In Belgium, JRS is very active in detention, and very often they meet people that have been already through several asylum procedures. And it's only when finally JRS at some point takes the time to actually talk to them and look for what went wrong in all these procedures, that then the suspicion comes out and arises that this person might be stateless. And then in that case, after the recognition comes the referral. So in that case, JRS refers to lawyers that are more specialized on this. In Belgium, there is also a statelessness determination procedure. However, so far it doesn't lead to a residence permit. This might change hopefully in the future. There is a government agreement on these days, but yeah. So that's the work that JRS does is more like recognizing, referring, and ensuring that the people are redirected to someone that can help them. And similarly, in the UK. Very often JRS finds people that have been destituted for a very long time, where nobody really took the time to understand why there was no recognition of their protection needs. At that point, finally, turns out there is an issue with nationality, and again, what JRS does is also referral. I will get to my conclusion a little bit. There are many other examples where, of course, JRS is accompanying stateless people in Europe. I would say the common denominator and the way we try to improve the situation also of statelessness, of stateless people, without having really a mandate to work specifically on statelessness, is really the fact of being listening, being alert, try to recognize and ask questions and see where there might be making people themselves aware that there might be an issue of statelessness, investigate with them if possible, because as Patricia also was saying, very often finding even the evidence that a person might be stateless is really, really difficult, particularly when in the asylum procedure, because you cannot even ask the authorities of the countries where you're saying you come from to provide you with documentation, because those are the same authorities that are in fact they might be persecuting you. So it's impossible to actually even look for the evidences, and yeah, and then refer as much as we can to people who have more expertise than we do to further help. To conclude, I think I will just sum up a little bit the challenges that we see. Patricia already did it, but yeah, we find that there's very limited experience and expertise even among lawyers on this issue, and so in fact even referring, it's a challenge. The absence of procedure, well, when you have no procedure for the determination of statelessness, then you don't know even where to refer to. The inadequacy of the credibility assessment phased within asylum procedure. This is a problem not only for people in the situation of statelessness, but for many other asylum seekers. Credibility assessment is often focused at looking for lies rather than substantiating claim and helping people to actually make their story consistent and coherent. And then finally, all these procedures are extremely lengthy. Even when there are statelessness determination procedures, often they do not, in fact, guarantee other support. So there are legal procedures, but they don't ensure reception, for example. So asylum seekers in asylum procedures have a right to reception, but in statelessness procedure, not necessarily. So people have to just live in this kind of limbo without support, and very often end up in destitution. So voila, this was a little bit our experience from JRS, and over to you, Cynthia.
Great, thank you so much, Claudia. That was really, really helpful. And I definitely will second lots of what you've said. I've seen it in my own work as well. especially around the issues of destitution and the impact of really long, drawn-out procedures for many people who have had very significant difficulties in improving their cases. We're going to take just a few questions. We've got about 9 minutes. So the first question is for you, Patricia. It's a pretty basic one, I hope. What is a no-fault procedure, which I think was referred to in one of the quotes that you mentioned. So if you don't mind answering that one.
Sure, and thank you so much for the really lively chat. It's been hard to keep up with all the different questions and interventions. The no-fault procedure, I am not an expert in Dutch law, let me tell you that, and but from the information that we have, it is a specific procedure that exists in the Netherlands in the context of removal proceedings. So after attempting to remove someone to a certain country, if that fails, the Netherlands has a no-fault procedure, which essentially allows someone to apply for a residence permit if they're unable to return due to no fault of their own. So this is a procedure that sometimes countries have after removal procedures. But it is also it's quite problematic because it doesn't allow for formal recognition of statelessness, and it has very stringent burden of proof. So it's not at all ideal. But in this particular case, in the quote was the solution that ended up being available for the collective. But I can see that I think Claudia may also want to add something on it. So,
yes, please, Claudia, if you've got anything to add on that.
Yeah, just because I'm a bit familiar with the legislation in the Netherlands. No fault, it basically, Patricia, you said it, it means it's in fact more of a non-returnability kind of procedure. It's a regularization procedure, and people need to show that out of no fault on their own, they are unable to return and to be sent somewhere. So in that sense, yes, it's not linked necessarily with statelessness, but it's more linked with the issue of non-returnability, not removability, and in that sense, it helps somehow to regularize situation of people that otherwise would be undocumented.
Yeah, and absolutely, and hopefully, if decision makers and judges are more aware about statelessness, they will recognize more easily that it's not someone's fault if they can't go back to a former country of residence because they're stateless. So thank you both for that. And we've got another question coming to you, Patricia. Could you share, please, some references of successful examples of referral procedures between asylum procedures and statelessness determination procedures? If there are, I know there aren't tons of them, but if you're aware of any, please share a little bit about them.
Sure, that's exactly the question that we're hoping. So next time we do a webinar like this, maybe in 2 years, I'll have more examples to give you, because in the meantime, states have implemented more referral mechanisms. But it is actually something that is quite negatively assessed in our statelessness index, which is the tool that we use to monitor law, policy and practice in 30 different countries across EU. So it's really quite difficult to find good practice on this. But I did mention one during my presentation. So in France, for example, the Office for the Protection of Refugees and Stateless Persons, as well as the Ministry of Interior, UNHCR, all of them can refer people to the stateless and determination procedure. So it's not an official referral mechanism per se, but this can happen. It does happen in practice as well. And then, for example, if a person applies for refugee status, but the authorities want refugee status, although there is a risk of statelessness or it has been identified during the procedure, then the authorities inform the person about the stateless determination procedure and the possibility of applying for it. In Moldova, there are also cross-referral mechanisms between asylum procedures and for example, if a person has already applied for the stateless determination procedure, but then also applies for asylum, then the stateless determination procedure is suspended, and then it is afterwards resumed if the refugee status is refused. So there's a few examples, but not incredible good practice around it, which is really what we're hoping to improve.
Absolutely, few and far between. And I know this from some of the work that I've done in the UK as well, that there's very occasionally some cross referral, and it's really maddening because it's actually the same government agency that deals with those kinds of cases, and it should be really easy for states to arrange a referral from the asylum procedure to the statelessness determination procedure. But as you said, unfortunately, it doesn't happen as much as it should. So thanks for that. And we've also got another question, and I think it's more for you, Patricia, but Claudia, do feel free to add to anything that Patricia said about this one. So the question is, when would we recommend creating a referral mechanism between asylum and statelessness determination procedures? And do we see the person's consent as a requirement for this referral to take place? And the person asking said they were thinking of cases where the person doesn't want to be recognized as stateless and they insist on claiming to be a citizen of their country of origin. So this is obviously a slightly tricky situation. So Patricia, any thoughts that you have about that?
Yeah, it's a really good question, and one that is definitely not easy to answer as well. I think the first thing that we're really concerned about right now is the fact that there's just very little information available, or any kind of refollow whatsoever. So people may be refused refugee status, but they are not even informed about the possibility of acquiring protection as a stateless person. And so most of all, we're really concerned with just making sure that that level of information is provided. And then obviously, I do think the person should always be involved in the procedures. How exactly that consent is given and how exactly the procedure works, that's something that can probably have different be reflected differently in different countries. So each country can adapt its own procedures to how exactly that is made, but at least allowing the person to have that information available. And if the person consents to it, having information that has already been shared within the context of one procedure, also used in another procedure to also facilitate and make the procedures more efficient.
Yeah.
These are my initial thoughts on it, but I think it's a question that is definitely worth more thought as well.
Yeah, great, thanks. And Claudia, do you want to come in on this question? I think you mentioned a little bit in your presentation about some people that JRS has encountered either not being aware that they are stateless or not necessarily wanting to make a claim based on statelessness, but preferring to proceed with their claim for asylum and just be recognized as a refugee.
That was more a strategy of JRS to ensure that they will get a protection status in the absence of a statelessness determination procedure. So in that sense, it was like, okay, there was a clear claim. It was not really the person saying, I'm a citizen of this country. It was more like there might be a risk, but it's not even that. Let's not even focus too much on this risk of statelessness. There is a clear protection need. The person comes from this place, that it's clear, the legislation is clear that a refugee, the refugee status determination is done towards the country of origin or the country of habitual residence. So we don't need even to be sure about that. Let's just give a protection status. So that was a bit more it was less an issue of referral, or it's just the fact of a strategy to ensure the person gets protection in the end. So I think the issue of referral and consent is very important, and I obviously don't think anything should be done without a consent of the person involved. But in that sense, I would like to stress again the point of accompanying people and case management, or listening to people and unpacking with them also their situation, and what it means, or what are the consequences if someone insists to say I'm a citizen of this country, but there is no evidence of that, it cannot prove it. What does it mean? What will be the consequences for the person, and what is then what are other paths that are there, and what would be the advantages of being recognized as stateless person if there is a procedure. So I think that's really the key. The every step should be done together with the person. In any case, this is valid for everything, also in a regular asylum procedure and with refugees that are not stateless, but definitely even more in these cases.
Yeah, Right, thanks. And I definitely agree. I think it's really, really important. And it really shows the value of good legal representation, which has such an important role in this kind of scenario where people may really not understand what the consequences of failure to identify statelessness will be for themselves when it comes, for example, to somewhere down the line, if if the situation changes in a home country and they potentially could go back because there's not a risk of persecution, but if they're stateless, they won't be able to go back, or they'll go back to a very, very difficult situation that is different than for refugees who have the nationality of that country, or it will have an impact for their children potentially to be recognized as stateless or to be granted the citizenship of the country in which they're born in a host country.